Hello, and welcome to a new edition of Need to Know, a series of video interviews with companies who are shaping, creating, and innovating in the games industry today, and whose work will have a huge impact going forwards into the future. Today, I'm delighted to welcome Sean Waterman, Head of Intellectual Property at Naomi Korn Associates, here to talk to us today about navigating copyright and commissioning in video games development. Sean, it's lovely to have you here with us today. Thank you so much for joining us.
Oh, thank you for inviting me.
No problem at all. Before we get going, do you want to tell our viewers a little bit about your background and what it is that
Yeah,
you do?
sure. I'm head of intellectual property at Naomi Korn Associates, and I joined about 2 years ago. My role involves delivering a lot of training for our clients so they can understand, especially copyright and how it affects them, how they navigate around copyright. And we also provide support to a lot of institutions looking at their IP policies or their practices, but basically help them to in a practical way to understand copyright and how it impacts what they do.
Fantastic. No, that's really, really good to hear. That's very helpful. We should jump straight in then. It'd be really interesting to hear from your perspective then. I mean, what are those key intellectual property considerations when commissioning content for video games?
But the first thing to say is it's really important to whenever you are either being commissioned or especially if you're commissioning that you have an agreement that has IP clauses that deals with all the considerations that I'll go through in a bit, because it's all about having clarity. It's all about having a clear idea of who owns what, ensuring things the outputs are going to be legally protected, and ensuring that the future use of those materials is guaranteed, and everyone basically it's clarity around everyone knows who owns it and who can do what with it. And yeah, as I said, that clarity is best ensured by ensuring you have a contract and the IP clauses. Well, the probably the most important one is about who actually owns the intellectual property in the work that's been commissioned. Yeah, who the owner is. And in the UK, the owner of copyright automatically belongs to the creator of the work. And unless the creator is an employee, in which case the employer owns it. So what happens if you are contracting a freelancer to do some work for you? And in that case, the freelancer would own the copyright unless there is in a contract explicitly in writing that the ownership of the copyright has or any other intellectual property rights has been assigned. It's all about an assignment clause. This transfers the full ownership of the copyright to the contracting party. So that's vital. If you are a contractor, if you're contracting, you need to have that assignment clause. It's really important. However, in some cases, full ownership might not be transferred. So in which case you're relying on what's known as a license. And there are basically two different sorts of licenses you might be looking at. The first would be what's known as an exclusive license. So the exclusive license means the commissioning party, they will have the exclusive right to use the work that's been commissioned. They're the only ones who are going to be able to use it. However, if it's a non-exclusive license, this means that the contractor, the freelancer, they're free to then allow other people to use the work. So it's really important to consider, if you're not transferring the ownership, whether it's an exclusive or a non-exclusive license that's being granted. If a license is being granted, it's really important that you specify the permitted uses of the content that's being created. So, you know, what platforms is it going to be used on? What modifications can be made? Can it be used in marketing? So it's really important to have a really good think about how it is that you want to use it. And also you need to think about the longevity of what's being produced. You might get lucky and there might be sequels to your game, or expansions or adaptions. So you need to make sure that the rights will include this, if that's a possibility. So always have your mind on what might happen in the future rather than just what's going to happen now. So as well as either assigning the the ownership of the copyright, or granting a license, there's another right that you need to consider, and that's what's known as moral rights. So moral rights are always retained by the creator of the work. They might assign the copyright ownership to someone else, but they retain their moral rights. And the moral rights include the right to be identified as the creator of the work, and secondly, the right to object to derogatory treatment, by which we mean making adaptations, using it in a way that the creator might find damages their reputation, for example. And so therefore, you'd need to think whether or not the moral rights are going to be waived by the creator, in which case there's going to be no problems for in any way how that work is going to be used. There's no need to credit. You can change and adapt it as you will. But if they're not being waived, and you should consider that creatives want to be credited, so you would need to think about define in a contract how and when a credit will appear. So get it down on paper. And also, if their work's going to be modified, specify whether or not that is the case. So yeah, always have a discussion when you're in contract negotiations about these possibilities.
Absolutely. These are all really important key areas to be including in those contracts, aren't they? For sure.
Yeah.
Okay, that's good. I mean, we've talked about sort of the creativity, the development side of things. I mean, be interesting to hear your thoughts on the sort of performers side of things for games. I mean, how can performers' rights be protected and respected when it comes to games development?
Okay. Yes, performance rights. So whereas the copyright is going to be protecting the creative works that might be used in a game, this might be the scripts, the character designs, or indeed the recordings of the dialogue. Performance rights protect the actual performance itself, the voice, the acting, and the motion capture. So where copyright belongs to the creator, performers, they retain certain rights over how their recorded performances can be used. So it's a very similar principle to copyright. And so some of the areas you need to consider is, are you going to be recording a voice? Are you using motion capture for someone, or are you using someone's likeness? So it all needs to be managed in a way that's legally compliant, but also fair, because performers' rights are protected in the Copyright Designs and Patents Act 1988, and also will be subject to contractual agreements. So how do you protect and respect those rights? Well, first of all, as with copyright, you need to consider who owns those rights. So are they employees? Again, just like with copyright, in which case it's likely the employer will own the rights that they have. But if they're not, well, then again, you need a contract. And one of the avenues in a contract would be that, just like with copyright, you would be assigning those performance rights to the contractor, who might be the developer or the publisher. They will own those rights. However, it might be that a license is granted, in which case the performer, they're going to retain ownership, but they're, just like with copyright, they are going to be granting usage rights and these need to be defined. So yeah, how long are they allowed to exploit those rights for? For example, what's the duration? Um, what's the scope in which that performance that they're given is going to be used, and is it exclusive? And in a similar way to the moral rights that creators have, performers also have moral rights as well. So they have the right to be identified as the performer. And they also have the right to object to derogatory treatment of their performance. So therefore, this needs to be taken into consideration as well, just like with the creators, about how they're going to be credited and how their performance might be edited and used. So you might also want to consider how in the game you're going to credit. Is it going to be like like in a film at the end where you've seen in the films you have that long list of credits? Are you going to have something similar? You also have to consider their likeness, their use of their likeness. So are you scanning their face or their body? You might want to outline how their likeness is going to be used and whether or not they can be used in modifications, used in sequels, downloadable content, remastered versions. You need to define exactly how it's going to be used. This avoids disputes in the future.
Yeah, absolutely. I mean, these things all sort of serve to protect the creators and protect everyone involved. Ultimately, I think that's always worth bearing in mind with any sort of navigating of copyright or intellectual property. I mean, you mentioned the sort of disputes there. I mean, what strategies would you sort of suggest, sort of putting in place to avoid such IP disputes especially when sort of collaborating on game projects, like how a co-developer might work with another studio.
Yeah, so I mean, in a contract, you can outline how disputes might be resolved and how the contract will be enforced. So with both with the creators or the performers, or if you're collaborating, really important that you sort of outline how disagreements are going to be settled. And part of that is to say which legal jurisdiction will be used. And if you're in the UK, it should state that it's being that the UK law is going to apply to the contract. But you might specify that there'll be some sort of industry arbitration, for example. But yeah, you can put that into the contract about how disputes might be settled.
Oh, that's really, really helpful to understand. Certainly from a UK business perspective, that's really, really good. Um, Fantastic. Well, thank you, Sean. I think there's an awful lot here to consider. I think it's definitely worth sort of maybe noting that I mean, Ukie has a wonderful relationship with Naomi Korn Associates. We sort of partner on a lot of training with you guys. A number of training sessions that we provide in partnership, which I will link to down at the bottom of
Thank you.
our video, of course. So yeah, I mean, I don't suppose there's anything else that you wanted to add in terms of, how you see the
Well,
sort of things evolving, perhaps, especially given the given the changing landscape that we're encountering at the moment.
I would say maybe keep an eye on developments in AI.
Hmm.
It is uncertain the degree to which a work that's purely generated by a computer, by AI, what copyright protection it's afforded. In the UK, there is a limited amount of protection for works that are purely generated by a computer. However, this may change. There is a massive review going on at the moment with the UK's Intellectual Property Office, where they're looking at how artificial intelligence, how it interacts with copyright. And so the legal landscape may change, but it all comes down to the degree to which there is human intervention, whether or not the degree to which something is protected by copyright. So yeah, I would say keep an eye on whether there are going to be any changes regards copyright and AI. And also there's always the question whether or not AI has copied someone else's work. So the outputs that you might use How are they potentially infringing someone else's copyright? So yeah, AI, I think, is one of the biggest issues. I mean, we touched upon that around the use of AI to generate people's likenesses, and so that's why it's important that maybe there's explicit agreement that you can do that and how those likenesses can be used. But some of the other areas we didn't get to touch on and that I think are important, it's about payment. So, because everyone wants to be paid, yeah, we might love what we do, but at the end of the day, it's a job, and we got to earn a living. And so, as part of any agreements, whether it's to do with a collaboration, or whether it's to do with you being a performer or a creator, it's really important that a contract addresses payment. Is it going to be like a one-off fee, a flat fee, and that's it? Or is there going to be some sort of revenue sharing through royalties? If the game takes off, are they due a share? So payment, having down in a contract how someone's going to get paid is very important.
Absolutely. No, you're absolutely right there. Awful lot of things to consider, I think. Yeah, well, thank you so much, Sean. Like I say, I think there's an awful lot there to consider for companies. It's been really fascinating talking to you. Like I say, I'll link everything
Thank
in at
you.
the bottom of our video here. Yeah, thank you so much, and thank you as well to our audience who've tuned in today to catch this video. There's plenty of other need to know videos out there on our Ukie TV channel on YouTube. Thanks for enjoying this one, and more very soon. Thank you so much.
Thanks, everyone.